camera. Good morning, Sunday morning things. It's not really morning. It's not really any of that. But it is Sunday. That's accurate. And I am here speaking to you, our internet audience, with a lovely and illustrious guest. My guest here, Matthew Shirizio. Say good morning, or to good day, or good afternoon.
Good day.
Good day. So, normally we do a Sunday show, the Speaker's Corner, with an illustrious cast of 3 or 4 or 5 or more or whatever. And this morning, due to schedules and whatnot, we are bringing you a special guest in lieu of our typical individuals. So, this week you will be speaking with a practicing lawyer in the state of Texas in patent litigation. And
right.
We will be discussing a few of those things and the news of the day. So let's get into it. Hold on. Was there an audience that enjoyed? That's good. Okay, so that brings us to, by the way, my name's Jeff Wheeler. We're both sitting here under the shadow of the Gold Dome here in downtown and illustrious Atlanta, Georgia. Atlanta, Georgia, I should turn down the sound so you can't see background. Atlanta, Georgia, where my friend here is traveling and is visiting for this show specifically. He is here to be with you, our audience, and there really was no other reason for him to be here. So let's get into it and say a few things about a few things. So in general, Matt, may I ask you, there is patents are a thing that influences many things in our technology world specifically. And this audience and this group, and medical, and this audience and this group have been keenly aware of how the patents and patent trolls and patent litigation affects the prices that we pay for the goods and services that we want, in addition to it affects what goods and services we're able to get in the marketplace because one person sits on a patent and doesn't do that. Can you share with us a few insights as to the enormity of the cost that is incurred with patent compliance and regulation and legal garbage?
Right. Well, from the get-go, to secure a patent takes a considerable amount of money. Usually involves several lawyers to even prosecute a patent to the PTO, the Patent and Trademark Office. Most patents take a few years to even get approved and get issued, from application to issued patent. So that's expensive, and then you have to protect that interest once you've got it. You spent that money.
Then you have to troll the world to make sure that nobody utilizes that.
Otherwise, that money was wasted. But with the so non-practicing entities.
Non-practicing entities, for those who don't know, is commonly referred to as patent trolls. It's a group or an organization that holds a patent to something that they don't exercise. They don't do anything with it. They don't make anything with it. Is there any particular instances that you can picture of a non-practicing entity that our audience might be able to see or hear or know about? Kind of a quintessential example?
I mean, you could put some universities into that category because they often hold a lot of patents and don't sell anything. But good universities also usually have offices that will handle their patents and try to monetize them by licensing them to other entities that would then practice the patent on a legal basis.
Right.
But there's a debate over what needs to be done about non-practicing entities, if anything should be done. A lot of people get upset about the patent trolls who don't do anything except sue people. I'm not sure that's the right answer.
Expound, because I am one of those people who feels like patent trolls, non-practicing entities, in general, are sapping the ability of our society to make things by just sitting on intellectual property.
Right, but I think you can it's a legitimate business model to own intellectual property. It's
Well, just
the
like somebody
patent is
can
valid.
own real estate. If you buy up a bunch of real estate in a particular area, you're going to drive up the price of that given real estate.
Mm-hmm.
And so it's a viable business concept to do that in real estate. Is your proposal that it's perfectly okay to do that in intellectual property as well?
Sure. I think there's no real, just because someone's not selling the invention doesn't mean that they didn't have a right to the patent for the invention that they created.
Understood.
And they can sell that patent to someone else.
Okay.
And if that's the way that they want to monetize it, by licensing it.
Or by just selling it once and never licensing it and just going after people
Right.
who utilize that skill or ability. Okay, so also one that I see in articles that I read on the internet, and I don't know all of this and the intricacies like you do, but I see there are many things that are very elementary and basic to the functioning of what we know of as the world.
Mm-hmm.
And somehow, some way, someone was able to get a patent on something that is sillily obvious to the casual observer in today's parlance, right? So the swipe to unlock, take across a screen and slide it. Apple has a patent on that,
Mm-hmm.
which in today's world seems insanely silly.
But
At
was
one
it-
point,
was it
Motorola...
obvious before everyone had an iPhone or an Android phone that you slide to unlock?
No, it wasn't. It wasn't.
So that's when they invented it.
Okay.
Before it was obvious, right?
Right, okay. So once it becomes obvious because one person did it, right? It comes
That's
comes
the point
down
of the
to
patent.
right. I guess my point in that is that they should have first to market rights. They should have a sunset and a horizon
Sounds
on
like what
that.
you're saying is that the 20-year patent window is too long.
The
in
20-year
with
patent
technology
window
today.
does not make sense in the technology world, right? So in the days when you were building a
Cotton
furniture
gins.
or a cotton gin, right, it would take you a year to produce something, and then it would take 5 years to promulgate that to be everywhere, to get these cotton gins to be from Iowa all the way out to France, and to be really utilized. And then you've got 1 or 2 cycles of the business cycle in order to profit from your idea. And I believe that somebody who comes up with a good technology patent should profit from their idea, but it should just be in the horizon of what that business is.
So different patent windows for different inventions,
Correct.
different fields.
So, for example, I feel like the swipe to unlock should have about a 3-year to 5-year window on it.
When did the iPhone come out?
Because the iPhone came out, the original iPhone came
the
out.
First iPhone.
I think I'd have to check the internet, but I think it's probably 2004.
Did the iPhone come out before the iPod Touch?
iPod Touch, yes,
Okay.
but not before the iPod. Ziggy, do you know what that is? Well, let's see if she can find out when the first iPhone came out. So, just as an example, I would say you should have the amount of time that it takes to bring something to market for that business, and then have 2 replacement cycles in that business. Whatever that thing is should be the maximum of that any one given business. So in a car, for example, they typically have those cars for 4 years or 5 years as their warranty period, right? Some of them 10, but
3
generally
years, 36,000 miles.
3 years, 36,000 miles is pretty standard. So give them the time it takes to make a car, which is, call it a year to 2 years, plus 2 times 3. So give them 9 years on a car patent, so that they have 2 replacement cycles to profit from their idea.
So on a phone, you think
5 should be
time to
plenty.
market, 5?
5 should be plenty, because it's
Pretty
really
long.
time to market is about 18 months, 12 months from an idea to implementing it into software, et cetera, et cetera. And I think that should probably stand in most all the software fields, because software is the general upgrade cycle of those software pieces is a lot shorter.
And is that enough to maintain a level of innovation in these arts? You think 2 cycles of profit is enough to keep inventors inventing. Because that's your trade-off.
Right.
That's why we have patents, right?
So to
encourage people to invent things.
Right. Right. If I was I guess that's the argument. And in software, though, I think it would, because the patent is not really pertinent. You don't have the exclusive use in practice of these software patents. People just use them and then they pay you off to move on.
I'm not sure what you mean.
So they're like the swipe to unlock, right? Other people are using that.
Right.
In the technology field, people just use the patent, do the thing because it's the right way to do it, and then they deal with the patent litigation.
They get
later.
sued, and
lawyers make a ton of money.
Yeah.
And the businesses make some. It is important to some of us. It is important to some of us.
Yeah.
So 2007 was when the iPod or the iPhone was released. So 2007 till now, 2015. So we're at 7.5 years. So to me, the slide to unlock for that
should have gone away on
patent-wise
a few years ago. You said about 5 years.
Yep. Should have gone away on patent a few years ago. And then, to me, you should be more vigorous at supporting these patents for a shorter period.
Okay, so, and of course, the issue isn't that no one could make another phone without a swipe to unlock. You just had to pay Apple for the privilege if they were willing to.
If they were willing to sell
the
it,
privilege,
which they didn't officially sell to anybody.
Well, I mean, the other one part of patent litigation can be an injunction.
Yeah.
So.
Right, like there's another thing that Apple did, which is the tap on a phone number to direct dial. Right, and they have a patent on that. And Samsung took it out of all of their ROMs because they didn't want, there was an injunction against it.
Right.
Or maybe it was HTC that took it out. One of the major Android manufacturers took it out of their devices based solely on the fact that they were, there was a cease and desist or whatnot. What did you call it? Injunction?
Injunction.
Injunction.
Yeah. Just a court order.
So is there a solution that we can propose from this here pulpit? Or is there really a problem with the compliance cost? Because it sounds like there's a lot of dollars involved in all that stuff. Does it truly, the system as it sits now, does it encourage people to invent, or does it encourage people to write patents and sit on them? Does it work?
Mostly it works. I think it mostly works.
Okay.
The time horizon on...
We could come up with tertiary patent leases after the main one expires. That would make it more complicated, and laws suck when they are too complicated. Agreed.
Yeah. Well, and that's another issue when we're talking about non-practicing entities. Congress does like to get involved.
Yes.
And coming from the court side of things, from the litigation arena, the judges, and I think the patent holders and the parties getting sued for patent infringement would rather Congress stay out of the way and let these things get sorted out in court, because then it's a fact-specific situation. So you can apply it to this situation, whereas Congress is trying to handle things from a 10,000-foot view. Which is always a bad idea.
When they're writing such concepts. Yeah. About very specific details.
But the time horizon, I think that's an interesting idea.
And you just vary the time horizon based on what the thing is that you're doing. And software patents, in general, last for 5 years.
And you could write a pretty simple law for Congress to pass that would let the PTO then, via regulations, set those time periods.
Right.
They're the experts in the fields.
Right.
They have technical experts at the PTO who would be able to judge the business cycle of an industry.
Right.
And to base their regulations on that.
Right. Right.
It's an interesting idea.
Well, and the other thing you could do is implement the number of patent requests in a given field would then have a inverse effect on how long they would be good for. So if there are lots and lots and lots of patents in a particular field, that means there's lots of invention in that field, which means that you get shorter time horizons. And as less and less people do it, the time horizon just continually increases. And but that's something that you should do in the bureaucratic means and not on the legislative means.
Sure. Yeah.
When they're writing the Code of Federal Regulations at the CFR level, not at the law level.
Yeah. Another related area on that is standards patents. So patents that get included in a technology standard.
Okay.
We talked a little bit this weekend about the wireless.
Okay.
The 802.11 standards
that
the IEEE promulgates.
Yes.
And what they usually do actually is ask, when they're writing the standard, if they know that it's going to include a patent from someone who's a member of the IEEE, they will ask them if they are willing to license the patent on what they call RAND terms, reasonable and non-discriminatory terms, for anybody who wants a license, because it's going to be included in the standard that everyone's going to have to follow. And so they typically don't want to include patents in a standard if you're going to have a licensing holdout situation or some kind of patent holdup where no one's going to be able to practice the standard unless they pay $10 million per use to the patent holder, and that's ridiculous. Yeah. So usually the standard-setting organizations implement those kind of safeguards to help with this issue as well. Got it.
And the one that you were speaking specifically on in Wi-Fi, that was held by the government of Australia,
and the research arm.
The research arm of the government in Australia, and they held a patent for ricochet biscuits in Wi-Fi. The what do they call it?
The multipath problem.
Multipath problem, which is the same antenna will irradiate and bounce off of both walls and people and all kinds of other things and hit the target at different times, and those caused interferences and slowness in packets. And they found a magical way to make sure that doesn't. It's FM. It's effing magic. That's what it is. So, but they found a way to do it, and were able to patent it, and that got implemented in the 802.11a, G, N, AC, any further standards beyond B. So 802.11b does not apply that standard. All of the faster connections do apply to that standard. And so
CSIRO was a member of IEEE, and they were asked when the standards were being written whether they would license this patent on reasonable and non-discriminatory terms. And for 802.11a, they said they would.
Okay.
So they were bound, and this goes into like contract law. By being a member of the organization, you agree to abide by these regulations, etc. So any manufacturers who made 802.11a would have been entitled to a license on reasonable terms from Australian government. But then when G was being revised or talked about, they were again asked for a letter, and they declined to issue a letter.
Got it.
But the IEEE committee decided to go forward and use the same technology anyway, knowing that this patent would be involved. So I mean, that's up to the committees at the IEEE on how they do these things.
Yep. And that was probably one of the reasons that you couldn't get, there was draft in for the longest time. They were probably dealing with the same problem.
I mean, at this point, CSIRO was the Australian research government part was upset because no one had licensed the technology for 802.11a.
Right.
Even though there were people making it and selling it. And so they had asked for people to license it, and everyone just ignored them. So when G was coming around, they were like, well,
Never mind. you didn't give us reasonable any dollars, so you can go pound sand. So there you go. So time horizon should fix that. The standards, is there a solution to that standards problem?
I think the system tends to work. There's questions about what is reasonable and non-discriminatory mean.
That's right. That's right.
That can end up being litigated by itself. So
that's right.
It may not save anybody any money in the end.
Yep.
But that's up to the standards organizations to do, and I'd rather them handle that than have Congress get involved.
Stick their fingers in there. Yeah. Getting those fingers of the congressmen out of the way here. All right, so then I will go to a completely different topic for just a moment. Who are you in support of in the 2016 election?
I don't know who's running.
No one's running yet, officially. So knowing that there is no official candidates,
Yeah.
who would you like to see in the 2016 presidential
What do you
election?
think of Dr. Ben? What's his last name?
Dr. Benjamin Netanyahu?
No.
Dr. Ben Bernanke?
No. What's that guy's name?
Dr. Ben. Dr. Ben. Is he a politician?
I think so.
Or is he a doctor?
What about Huckabee?
Huckabee.
Can we get Huckabee back?
So Huckabee, I was a fan of Huckabee at one point, but his Fox News days has made me not as much a fan of Huckabee. Carson.
Dr. Carson, yes.
Dr. Carson.
Yeah, Ben
Who's Dr. Carson? Who's Ben
He's a
Carson?
libertarian darling.
Oh, is he?
Yeah.
Oh,
I
yeah?
think he's a medical doctor.
Okay.
But I don't know much about him.
My congressman from my district, Thom Price, is a doctor. And has been a long-time member of Congress from there. But
I don't know. It's too far out to
Ben
worry
Carson.
too much about it.
All right,
Read
so
up on Ben Carson.
I will read up on Ben Carson, and we will see what I can come up with as far as the correct person to vote for next week.
Next week.
Not next week.
I think
Next
I
year.
misspelled my last name.
I might have. Did I misspell it?
Yeah.
All right, well, I'm sorry to the internets, and I'm sorry to you. All right, well, thank you very much for joining us. I appreciate your time. We will talk again on the flip side, and thank you for your insight into the matters of patent, the world of patents.
Terrific.
So until the next time that our audience joins us, you do not have to think like me or him. But we're going to ask you as our audience to think. Thank you so much.